give us your best guess of what you think the range of outcomes might be, what the timeline you think is for them, and when talk a little bit about the various scenarios of getting this case to the Supreme Court and the timeline for that, and what elements might be. That's, I know that's about 10 questions.
I think I can get it in 2 sentences. Well, 2 sentences.
Don't take your time.
Yeah, I think what way will probably play out, the California Supreme Court will decide in the next month or two this standing issue. I think we'll get back to the Ninth Circuit very quickly. The Ninth Circuit will take this back up. They might have another argument depending on what the California Supreme Court held. But I would say by the end of the year, the Ninth Circuit will probably have ruled, or maybe early 2012. Once that happens, whoever, and I think we're either going to win on standing or we're going to win on the merits. I think and there are different ways the court could rule in our favor on the merits. Broad, narrow, both, alternatively. Then whoever wins on the merits or on standing, then there's a possibility of en banc review, and that's kind of
fairly likely, you think?
It depends.
Does one of the sides have to ask for it?
Yes. Although, well, actually, the court can sua sponte ask for en banc petitions. They did that once in our case already. We've had like 5 Ninth Circuit appeals already in this case. It's been a wild judicial run. So the court itself could ask for en banc. Judges can vote to take it en banc and kick the process off. So that's a possibility.
Do you do well if it's en banc? Do the numbers there in the Ninth Circuit help you?
I think the composition of the Ninth Circuit en banc, it's a random draw. But if you just look at the overall makeup and the rulings and the way the judges have looked at these issues, I think it's a pretty receptive audience. All
right. So, and on the merits, if this case gets before the Supreme Court on the merits, how do you get to 5 votes?
Well, I tend to be an optimist normally, but you have to be a realist when you're a lawyer and you're advising your clients. And if you look at the way the court has voted and the way the court's decisions are written, if you look at Romer versus Evans, look at Lawrence versus Texas, both were authored by Justice Kennedy. So it's no secret that we think Justice Kennedy should be receptive to our arguments here. We're basing much of our claims, Lawrence particularly on the due process argument, Romer on the equal protection argument, and if Justice Kennedy were to be joined by the four of the justices, we think we can 4 or more, and we don't write off any justice, and we don't count in anyone for sure. But with the Supreme Court, unlike a lot of other courts, you know who your audience is, and you can figure out how do they approach these issues, and that gives you the best possible chance of persuading them. And I think we have really strong arguments that will attract 5 or more votes, and that we wouldn't have brought this case if we didn't think so. And I think if you look at the way Proposition 8 came about, if you look at the evidence in the record, the fact that, like Romer, there was a right to marry, and it was taken away from one group solely because of their status as a minority group. There's just, on its face. In fact, the ballot materials say basically, you don't want your child to be like this. I'm paraphrasing a little bit. But if that's not the kind of antipathy or at least improper purpose that should warrant striking down a law, I don't know what would be. So we feel very good. We don't take anything for granted or any vote for granted. But we think because we've got this great record and these strong legal arguments and great clients, we're really well positioned. That's why I want to go to the merits. And not that I'm rooting for the other side to win on standing.
You'll take the standing.
Yeah, exactly.